Yes, ma'am.
State to mention items 31 and 32 on behalf of Mr. Anjay Dave. He is in hospital now and he will be discharged today or tomorrow. So let this matter fixed on visiting basis in the month of December.
You are mentioning on behalf of?
Anjay Dave.
Madam, we won't adjourn it at this stage. We'll see. We won't take it up today.
Discharged today or tomorrow.
It's okay because these are 2015 matters. Adjourning. And I remember hearing about this matter. I've asked him to make the payment. Has he made the payment?
You lost
Bring it. Let it remain in the list.
I'm paying for Uddhav is for tomorrow. For Uddhav.
Withdrawal. Which bench?
Is best 5. So best 4.
I beg to mention item number 10 of today's list. So in this matter, we have recently been engaged. We are leading by Dr. Ashok Saraf. Your Lordship, Madam Secretary.
Yes, what is this?
Hindustan Unilever. Hindustan Unilever matter. Dr. Ashok Saraf is leading us in this matter. Lordship, we have recently been engaged in this matter.
Has been submitted that the senior counsel will be appearing in this matter. Let's list this matter before him. Okay.
May I read your Lordship in item number 9? I have filed a rejoinder affidavit to the Lordship. Lordship kindly announce. I'm planning for getting a writ petition, Lordship. For motion, Lordship. Lordship, we are presenting a notice given by the CMC under section.
Huh?
We are in this writ petition, we are challenging a notice given by the CMC under 337, Lordship. Can it be come up tomorrow?
337 to 1 to
4, Lordship. 4, Lord.
day.
Tomorrow, Lord. Take care. I beg to mention for listing on WPC for withdrawal tomorrow or day after tomorrow.
Bench.
Okay. My senior K. Mudumdar is physical.
Huh?
My senior K. Mudumdar physically unwell.
Item
Number 35.
30.
High.
We fix it at 2 p.m.
Pass over the matter tomorrow.
But tomorrow. Can't be tomorrow.
He is not sitting.
Want an adjournment, it will be adjourned for 4 weeks. At the request of the learned counsel for a petitioner, matter stands adjourned to be listed after 4 weeks.
Your Lordship, I would like to mention item number 17. In item number 17, we have filed an IA, Your Lordship, for implementing. So I would like to mention that the IA may bring into the list.
IA for what?
IA for implementing, Your Lordship.
We'll see when the matter reaches.
Also, please. Your Lordship, I'd like to mention item number 37. The matter has become infectious. I'm appearing on behalf of TDAS.
We are appearing on behalf of?
TDAS.
No appearing on behalf of it. Get hold of anybody, RP Kautuki or T does. I can't say that it is infectious. Why is it infectious?
It's a transfer matter, my lord.
Transfer method.
Already the petition has been transferred from other places. Tenure case will complete in my lord. 2017.
The learned counsel appearing on behalf of the petitioner submits that the instant petition relates to a challenge to a transfer order. However, as the transfer order, as the period, why? Now, in the meantime, the transfer order has been given effect to. However, as the transfer order was given effect to long time back, nothing remains in the instant petition. I also heard the learned counsel appearing on behalf of the transport department who submits that the incident with petition had become infractional. Taking into account the above, the petition stands closed as infractions. Interim amount is again.
I'm so deeply applied.
Of the list, item 1, 2, 3.
Yes, Mr. Gautam, you come this side. Hey, बाकी भी करियो. Yes, what is your case?
Lots of. Lots of.
What?
Lots of. Help on me.
Mr. Chaudhary, the learned counsel appearing on behalf of the Finance and Taxation Department being not well. Matter stands adjourned to be listed when?
After 23rd. After 23rd.
Listed again now. No. For me to take.
Another prayer is there.
Impossible. I am not here from 1st of December to 12th. In the meantime, there is no time out here to be taken from in the next week. So we have it on 17th December if you want, or any other day. Whenever.
21st also difficult, lordship, it's 21st. Day after
21st of what?
very difficult.
He's still okay.
Lots of. Three of the matters were listed.
Then as for that,
When do you want it?
Okay.
You are in hurry because your amount is.
money is what?
It's okay.
But
That is
difficult.
why I am adjourning it today. When do you want it? Next week, not possible. You want it, I can fix it on 3rd of December.
Hard of money.
December,
Lordship.
it's the on 3rd of December.
There were what my landed was saying. Okay, that there are three matters were listed today before fourth number. While the WPC numbers, those may be also tagged there. Those have also got adjourned.
Along with,
Lots of.
along with a number. Keep the numbers.
For motion item 4.
Yes, what is this? How did you get a motion listed today?
Is connected to the series 13 to 28.
Huh?
It's connected to the series 13 to 28 listed today for this book.
Oh, that series. Hello, let us take up the entire series now. Where are the other councils? Who is appearing? You are the lead counsel.
No, I have filed this.
Who is the lead counsel? Mr. Bhattakur, you are there. Yes, Mr. Bhattakur, what is wrong? Yesterday there was a matter, nobody from missing autonomous council was
Lordship,
present. names have been shown.
I have skipped that, sir. I'm sorry.
After the order which have passed on 28, 2024, why is the missing autonomous council still disturbing? I think those orders were passed prior to
Lord-
that.
Lord.
I see that those orders were passed on 29, 6, 2024. For us, because the why I don't want now to say anything much on that petition, taking into account if I say anything, it will have an impact on the state.
Lots.
And he will be asking for enhancement of the settlement period.
Right.
Get the point?
Right.
So that is why tomorrow the
ask
matter is there. Can you-
Lots. I have.
and advise your people because of the order, because there is no challenge to the order of 28.
No.
It's, now let us, this is the series, you are there.
I am there, sir.
Okay,
I'll bring the file.
okay. Let's hear all the entire matters. There? Yes, what is your case?
The market has been settled in my favor now on 26th of June.
ये बाकी भी टिकट दे ये सीरीज full logo item number
from
14 onwards,
13 to 28.
13 to 28. Good, I'll be there.
This pertains to may place.
Yes.
It pertains to Lahori market, madam. Okay, what happened? The market has been settled in my favor, madam, on 26 June. Thereafter, office number notification.
Facts are like something like this. The markets were settled with these persons, which area is around 6 bighas. Out of that, 4 bighas, they have been working out there making constructions. Isn't it the case?
If for a moment, madam, comes to page 20, madam,
Of your reputation.
of my reputation.
Hey, I think
Four.
four. Yes.
What have come up, okay, no, this notification, madam, page 20,
Page?
20.
Yes.
By this notification, madam, the ongoing process of settlement, madam, were cancelled, madam, and it was directed that the existing lessees will continue.
Till
There is no, till new tenders are being floated.
so you have not been permitted.
I'm not, I was selected prior to the issuance of this
So
notification.
you were a lessee, but you were not permitted.
Permitted to run the market.
It is being permitted to somebody else.
Thereafter, my lord, petitions have been filed, my lord, and this honorable court has stayed this notification with regard to continuance of the ex-lessees.
So this notification has been stayed.
My case is, my lord, I am already been given settlement. And my settlement was on 26th of June. This notification came up on 29th of June. Now, by giving a retrospective effect, my lord, my settlement in my favor is not, they are not allowing me to run the market because of this notification.
So your case is that you have been settled already
Already, prior
So-
to
and your period is ending on a particular date. Where is your settlement?
page 16, man.
Page
16, 1/6. That is the translated copy, man.
from 1st of July to 30th of June.
Yes.
But the period is not starting.
So 1st of July 2024.
Understood.
Thereafter, my lord, the ex-lessee continued, my lord. Thereafter, a writ petition was filed.
So your case is that here this notification cannot be made applicable taking into account until the new tenders are finalized, the existing lessee shall continue. Meaning thereby, when a tender has already been finalized,
Final.
where is the question of application of this notification? That is your case. Okay, Mr. Thakur, what is your case?
My case, your lord,
Who is appearing in 3508?
lords.
You are there.
I am in your lordship 3652, your lordship.
Who is in 3508? Anyways. Yes, what is your case?
My case is your lordship, the NIT was issued. Then your lordship, pursuant to that, I participated in the process. And after participation, your lordship, order of settlement was also issued, your lordship. Then 29/6/2024, on 29/6/2024, order of the government, your lordship, cancelling the ongoing process of settlement was passed, your lordship. And thereafter, your lordship, on the same date, this Morigaon Jilla Parishad has passed consequential order, your lordship, and allowed the existing lessee to continue, your lordship. Did not allow me to participate in the
So item number 13 is different.
lordship.
Item number 13 is a case whereby he was an existing lessee
Lordship.
and he has not been allowed to continue
Lordship.
in spite of
That order.
the mandate as per 29/6/2024,
Lordship.
whereby it has been said that kindly allow those lessees, earlier lessees to continue.
Lordship.
That is his case.
His, our
But
case
the-
is
Your case is similar to Mr. Munir,
lordship.
that the entire finalization has happened, settlement order has been passed. or issued prior to 29/6.
Lord.
And as such, as it has already been finalized, the notification would not apply.
apply. That is one leg of argument. And secondly, your lordship, the settlement of these, your lordship, huts and park huts, your lordship, is your lordship governed by set of rules, your lordship. And that rules, your lordship, if we read rule 105
Of the,
Assam Panchayat Act, your lordship,
Assam Panchayat Act.
along with the rule 47 of the Panchayat Financial Rule 2002,
Now, Mr. Bhattapur, how many cases are yours?
your lordship. In the
Item
second
number-
case, your lordship,
Item number 16.
lordship, 5601 of 2025. Here, your lordship, agreement was also executed, your lordship.
53.
WBC 5601. Item number 24, your lordship. 16 and 24.
These are your matters.
Lord.
Okay. So your case, therefore, are both are on similar footing,
Lords.
except that in item number 24, there is already an agreement. also.
Agreement.
Why is the agreement required?
In every case, your lordship, an agreement is to be executed between the Panchayat and the SU.
Where is it? Assam Panchayat?
Assam Panchayat Act. Your lordship will see section 105, that
Yes, settlement
the
of huts.
settlement of huts by Anshalik Panchayat. Your lordship will find all huts within territorial jurisdiction of Anshalik Panchayat shall be settled in the manner prescribed for a period coinciding with the and not exceeding one Panchayat financial by inviting tenders at the office of the Anshalik Panchayat by its president. Detailed procedure for inviting and submission of such tenders shall be such as may be prescribed. And that prescription, your lordship will get it in Rule 47 of Assam Panchayat Financial Rules. That will be your lordship.
And all of you have already deposited the amount.
No, they have not, after your lordship passing of this order, your lordship, they have not accepted the deposit, your lordship. Now, my case will be, your lordship, apart from the fact that this notification will not be applicable to us. Your lordship, when a statutory rule is there prescribing a procedure and saying that highest tenderer will have to be accepted without amending that particular provision or the rule, your lordship, statutory rule by an executive order, they cannot, they have virtually amend the Rule 47 by issuing that notification, your lordship, which they could not have done, your lordship.
Rule 47.
47, your lordship. That is the prescription, your lordship, referred to in 105.
And there cannot be a question of extension.
Lords.
Is there a provision of extension? No.
No provision of extension so far as Panchayat Act is concerned.
So therefore, you have challenged the 29/6.
Lords.
In all cases, 29/6. has
All
been
cases.
challenged. 29/6 has been challenged. Only in one case. That is item number 1, 13.
They want this to be implemented and
He says that, but it has not been implemented.
Lords,
Who is paying for 13?
31.
Who is appearing for 13? Petitioner?
YS Mali. Mannan YS Mali.
So he is the only exception
Lord,
amongst the law. So your basic case is, without going into all other things, that the Panchayat Rule 47 categorically mandates a particular procedure.
Lord,
Read with section
105.
105, read with 47, mandates a particular procedure which stipulates that for every financial year there has to be a tender,
Lord.
and this tender has to be settled in a particular manner.
Right.
Tender has to be called 45 days prior to the
Right.
end of the prior to the finishing of the panchayat year, so that there is a continuance.
Right.
And the tender shall be settled with the highest bidder. And as such, this idea of the cabinet to override this system and give it to the highest bidder or to the existing bidder, it rehearse the
Rehearse.
rules.
That's not.
And further to that, you also would like to say that this, what happens if there is something, a wrong infirmity in the tender process? What is the course of corrective measures that can be taken?
That your lordship, exactly your lordship, these rules are provided. 105 your lordship may kindly provide your lordship. That is in respect of any dispute, provided that in case of any dispute, the Anchalik Panchayat may refer such cases to government and the aggrieved party may appeal to the government whose decision in this regard shall be final. That is in respect of your lordship any dispute. 5, failure to settle any hard for want of adequate value, the Anchalik Panchayat as may be decided by the Jilla Parishad may be entrusted with direct matters. And in fact, your lordship,
So there has been a confirmation in your case of the Jilla Parishad also.
Jilla Parishad, your lordship, settlement order has also already been issued, your lordship. That means your lordship,
Settlement order issued by whom?
your lordship will get it, your lordship. Jilla Parishad. It was by the Morigaon Jilla Parishad.
Jilla Parishad. So that is what, no? So it has been done under 105.
Yes.
Shall be subject to confirmation of the Jilla Parishad. So the dispute which is being referred, provided that in case of any dispute, the Anchalik Panchayat may refer the case to the government and the aggrieved party may appeal to the government in the decision. So that is a different aspect.
Different.
Failure to settle the doubt of adequate value, the Anchalik may decide to wholesale proceed from the dependent to the income. So if the tender has been held, is the issue not in conformity with 47. Let us take an example. What is the course of action available to the Anchalik Panchayat or even the government?
Lordship, will you kindly see your lordship, so far as these 47 is concerned, your lordship, it does not stipulate anything of like what will happen in that case, your lordship.
That is what I'm saying.
Lordship.
Because you have to understand that there is a cabinet memo on the
Lordship.
basis that there is something wrong may be there, and because of that we are cancelling this and we are going for fresh tender, and as such, it should be continued. Yes, it's okay. But what is what is available? If just for example, the tender conditions which are there to be mentioned, kindly see 105, 47, 47.
No, it lordship,
Just for example, the tender notice is not issued within 45.
lordship.
What is the course?
No, your
available?
lordship kindly say that if there is a violation of the rules by the Panchayat authority, your lordship, in that case, probably your lordship, government can interfere. Government can interfere. But your lordship, when it is as per the rule, your lordship.
No, therefore, I'm saying, see, there has to be a way somewhere.
Lordship.
when you are writing a judgment, you have to think about
Yes.
that. What is, how do you take care of a situation to that effect?
Lords. Lords.
If it is a case where he holds the panchayat rules, if it is done, understood. If it is not, then they cannot.
Lords.
The interference of the government could not have been there because of the fact that there is a, these are all constitutional provisions under
Lords.
which it has happened. Is it 243 article? So there is a decentralization of power. These are the powers which have been given
Lords.
to these panchayats to run. These are subject to various confirmation being made by the Jila Parishad, which is the highest out there. So this is being done according. Now then the government's interference out there is where? At what level?
Now, your lordship will kindly come to 4710. It can give an idea here. It says, your lordship, the tender of the highest bidder shall be accepted. Your lordship will find, then acceptance of tender other than the highest bid shall require the government's prior and formal approval, your lord. Now, whenever we deviate from the, your lordship, rule, that means, your lordship, then government can interfere, your lordship.
And number 9,
Lordship. The
the
case
case
of any disputed
the
matter shall
matter
be
may be
referred to the
referred by the
government under
government.
section 4, section 105, 401, 104, or section 4, section 105 as the case may be, your lordship. So, your lordship, rule itself prescribes, your lordship, to what extent, your lordship, government can exercise its power, your lordship. And that probably is, your lordship will have to see in the context of, your lordship, the constitutional amendment that has been brought in 1950. The purpose for which these panchayat Raj institutions are
In
established.
fact, if you see, there's one judgment where I passed. There's a lot of people were not getting the panchayat dues. So there I passed one judgment on that where I dealt entirely with the panchayat act. Why it was done? The basic reason is that to give decentralization of power.
Lordship.
And by this, the government has delegated their functions. Once you delegate, yes, you still have a control, but control is subject to the act when you have
Lordship.
bound yourself with the act and
Lordship.
the rules.
That is your
But I was just putting a question to myself that if there is a rampant illegality, what is the stand of that? How will the government take it? Just for example, 45 days is required. Panchayat and Jila Parishad both are together. What is the recourse available to the government?
lordship.
Are you saying that the government has nothing?
No, your lordship.
Then
Government
somebody
will
has
have
to
your-
somebody has to come to the High Court and get challenged.
No, your lordship. Government will always have, your lordship, that power, your lordship. If there is an infraction of rule on the part of the,
Where is the power? The
Your lordship-
source of the power is there, na, somewhere.
your lordship will kindly come to. This is removal of difficulties. In fact, your lordship will kindly see, they have relied on a section, your lordship, that is 122, your lordship. They say, your lordship, that they were given power, your lordship. And in fact, your lordship,
Extending anything contained in this act, it shall be lawful for the government to issue directions to any panchayat in matters relating to state and national policies. And such directions shall be binding. Often may call for the reports requiring.
C is important, your lordship.
So, she will say they require any panchayat to furnish any information or report.
On any matter connected with such.
No, 122, 1, notwithstanding anything contained in this act, it shall be lawful for the government to issue directions to any panchayat in matters relating to state and national
National
policy and such directions shall be binding on the panchayat.
Right.
So this gives an overriding power over the state.
Lords.
They can do so. But your question is the question of extension.
Right.
The government could not have done taking into account that in the act there is no provision for extension.
Right.
One. Secondly, the government could have done any taken a resort to 122(1), subject to they having the reasons to do so.
Right.
Without that, they cannot.
And your lordship will kindly see if they are allowed to exercise power under 122, your lordship, in this manner, your lordship, then virtually the entire act, your lordship, will become redundant, your lordship. They can pass any direction. That is why your lordship.
But you are not challenging 122.
No, I am not saying anything, but your lordship, 122 is qualified by state and national policies, matter relating to state and
State and
national
national
policies,
policy, not other than that.
not other than that. That will have to be your lordship consider. And your lordship will kindly come to the constitution provision, your lordship, 243 H, your lordship.
Two 243.
H. Is power, your lordship, is relatable to 243 H, your lordship, of the panchayat, your lordship. Powers to impose the excess by and funds of the panchayats. The legislature of the state may by law authorize a panchayat to levy, collect, appropriate such taxes, duties, tolls and fees in accordance with such procedure and subject to such limits. And your lordship will kindly see 122 can be relatable to 243 ZB, your lordship.
So the power which has been given to the panchayat is already there by the Assam Panchayat.
Yes.
So the government has already exercised 243G and 243H and given the power for the purpose of taxation. Overall, the government has the power, subject to it being coming within the ambit of state policies and national policies. Apart from others, the government's interference would be contrary to the act.
And they can, your lordship, only by bringing an amendment to this particular provision. They can do it by bringing an amendment to legislation to this particular provision. And 122, your lordship will kindly note, 243 ZB, powers, authority and responsibility of the panchayat. Subject to the provision of this constitution, legislature of the state may by any law endow the panchayats with such powers and authority as may be necessary to enable them to function as institution of self-government, and such law may contain provisions for the devolution of power and responsibility upon panchayat at the appropriate level, subject to such conditions as may be specified therein. Condition will have to be specified in law itself. The preparation of plans for economic development and social justice with respect to the preparation of plans for economic development and social justice, the implementation of schemes for economic development and social justice as may be entrusted to them, including those in relation to matter listed in the 11th schedule. Now, your lordship will kindly note 122 is there, your lordship, to in consonance with this 243ZB, your lordship. There, your lordship, there may be schemes, your lordship, which are central schemes, state schemes. Even your lordship has seen MNREGA, Your Lordship, implemented to the panchayats, Your Lordship. Now, if there is a policy decision on the part of the central government to implement MNREGA in a particular manner, now, Your Lordship, the MNREGA says, Your Lordship, that it should be given in preference should be given in village infrastructure development. Now, government has taken a policy decisions that I will spend this money in different aspects, Your Lordship. Then guideline will have to be issued. That power is given through under section 122. And in some cases, Your Lordship, if what Your Lordship has suggested that there is a violent infraction of the rule, then also panchayat authority, the government can call report from the panchayat. But if that
And
is
the
not,
government then calling report, would the government have a supervisory jurisdiction?
Your Lordship, 122 says, so, Your Lordship, that means, Your Lordship, in case of infraction. If it has been followed at all, Your Lordship, there is no violation at all. If the government exercises its power to section 122, the very purpose of bringing in this institution will become, Your Lordship, redundant, Your Lordship.
And what is 123?
Restriction or withdrawal of power and functions of the panchayat, notwithstanding the transfer of any power, functions and duties in respect of any matters to the panchayat under the said government on a proposal from panchayat in that behalf and where it is satisfied that by reasonable change in the nature of the matter, such as the conversion of primary health center into secondary health center, conversion of multi-purpose farm into agricultural research from a road becoming part of highway, any other thing. The matter cease to be a matter of the relevant panchayat council. It is necessary to withdraw from the panchayat the power and functions of duties. Such matter may by notification in the official gazette withdraw such power and functions duties with effect from the date specified.
So here there is no notification.
And that will have to be on the proposal of the panchayat.
Yes, government, what do you have to say? What is this? Government interfering unnecessarily? Why? Where is your affidavit? Affidavit filed in which case?
have filed it in Alimuddin's case, Your Lordship.
There is one affidavit.
WPC 3632. Your Lordship.
83632 conduct.
Yes,
That's Mr. Botaku's case, huh?
yes, yes.
Hey, Loksun Kumar Asani. 3632 conduct. Yes. This is your scheme. So you want to add a, what do you call that? Bible rate.
Yes, yes,
You want to add a Bible rate.
yes, yes.
And you became clever only on 29/6.
Yes.
Isn't it the mandate for issuance of a tender prior to 45 days? Why didn't you do it? Why didn't you wake up then?
Lordship, this is a policy decision, Your Lordship. Your Lordship, the government can take the policy decision.
What?
Government take the policy decision.
What policy
interest of
decision?
the
You
larger
take a
party.
policy decision, very well, take a policy decision. Nobody has asked you not to take a policy decision. But take a policy decision prior to that. Why you are affecting this ongoing tender?
So kindly see the page number 28 of his writ petition.
What?
The notification also, there are two parts.
Which notification?
Page number 28.
Two parts, yes.
Pursuant to the decision taken in the meeting of the Honorable Cabinet held on 27/6/2024, the Governor of Assam is pleased to cancel the ongoing process of settlement of the Ghats fisheries ponds, etc. for the year 2024 to 2025, for which NITs were already formed. Until the new tenders are finalized, the existing lessee may be given extension as the settlement value fixed for the year 2023 to 24. This is the first one. The second part, as complaints have been received at various levels, that the small traders, vendors, and the other sellers in the huts and bazaars, etc., are often exploited by the bidders who quote exorbitant high bid price to grab the lease. The Governor of Assam is further pleased to make provisions that no settlements shall be made with the bidders who got more than 10% of average settled value of the last 3 years of these huts, etc. Accordingly, the new NITs will include this condition, and such modified NITs should be reflected for settlement of the huts, etc. for the year 2024. So, Your Lordship, is the policy decision, because Your Lordship, the second part reflects it, Your Lordship. Because there's a larger interest involved.
What is the larger interest?
Larger interest, that means the small vendors and the,
Simple words is you want to have a viable rate.
yes,
That's all.
yes,
But why didn't you wake up early?
Your Lordship.
In the midst of everything, where everything has been going on, why did you wake up? Now who is losing the revenue? Tell me who is running the
Yes, Your Lordship,
huts?
Your Lordship,
No, who is running the huts now?
under section 105, subsection 5. There is the procedure when in such situation who will run the.
Who is running?
So now Your Lordship, Ansari Panchayat is running the market.
So, is the answering panchayat getting the money?
Yes, Your Lordship.
How?
(105) subsection 5. Failure to settle any hut for want of adequate value. The Ansalik Panchayat, as may be decided by the Jila Parishad, may be.
This is a case of adequate value.
Your Lordship, here is also.
Yeah, are you saying that you are not getting the amount? You can import these conditions from there or there. What is the national policy or state policy involved? You have a state policy very well. You implement it. You have no business out there. Somebody complains out there, and on what basis are you allowing the earlier traders to go on? Earlier lessee?
Your Lordship, that has been stated by this honorable.
Luckily, it has been stayed. One can very well import that the government's intention was that all the earlier lessees we were running should be again continued for 1 year.
Lordship,
The stay which is there is only to that extent.
yes,
We issued a new fresh NIT.
we have not yet.
Then?
We have not received.
Then
Your
who
Lordship,
is going to lose?
Your Lordship, your department has formulated the modified NIT. Now it is pending before the cabinet subcommittee.
So
The final approval is yet to be given by the cabinet subcommittee.
do it next year. Or next year do it. What is there? We are already in the month of about to reach December. You need 45 days for the next tender. So by the time it will be over, the cabinet will be doing it.
Your Lordship, so far as petitioners are concerned, so far as they are concerned, Your Lordship, they are on their personal interest, only private interest. They are private interest. So Your Lordship,
Private interest, obviously they have come up for private interest. They have got the settlement. They are challenging this
Yes, staff
notification
order.
on what basis you are
Settlement
doing.
is not given to them.
Huh?
Not yet. It's not, your lordship, it's a contract matter, your lordship.
Then?
The conditional acceptance was there. Conditional acceptance was there. They never accepted before their acceptance or our conditional acceptance. We have cancelled our tender process. That power is with us.
Where is your tender process cancelled?
So lordship,
Show me.
your lordship kindly see page number
30.
30 also. The contract matter, it's a commercial transaction.
Don't worry. We set aside this notification. The Jila Parishad will take a basis of this order is this. If this order goes, nothing remains. Chalo. That's all. We dictate.
Lordship, they,
I'll dictate now.
your lordship, they, the settle law also Supreme Court is very clear. We
Show
have
me.
the power. Your
Supreme
lordship,
Court.
they,
I allow you, then give you that liberty out there to go to Supreme Court then. What does the Supreme Court say? That the state government, as per their own wish, can interfere. Yes.
1969, 3
Hmm.
SCC 146, your lordship.
Yes. What does it say?
The full name's outcome. Paragraph 4, your lordship. One four six. Paragraph 4, your lordship. From the middle portion, your lordship, may I read, your lordship? If therefore the clear that the contract of sale was not complete till the bid was confirmed by the civil court also. The next paragraph. An acceptance of an offer may be either absolute or conditional. Here is the conditional. If the acceptance is conditional, the offer can be withdrawn at any moment until absolute acceptance has taken place.
Then
This view
how is it relevant? The poor
yes, sir.
kindly come to 47, rule 47. Kindly come to 47, 10. The tender of the highest bidder shall be accepted. This is the mandate of the rule. Acceptance of tender other than the highest bidder shall require the government's prior approval. We are not concerned with that. Now kindly see 11. On acceptance of the tender, the panchayat concerned shall inform the selected tenders concerned requiring the tender to submit within 7 days from the date of issuance of the acceptance letter, this. At this stage, you inform them that look here, we are giving you this, you kindly do this. While this 4711 process was going on, you come up with 29.6. So this court is only concerned with 29.6. If it is bad, to set aside. And consequential orders, which is bad, is bad. Thereupon, what happens from 47.12 I'm not concerned. Why should I pass any orders? That is your lookout. Whether you enter into a lease with them or not, I'm not concerned with all those things. I'm concerned with 27, 29, 6 cannot be made the basis. Because there are requirements of certain formalities to be done by them, which is subject to. How can I direct anything? I may say that once it has been done, nothing remains. How is this judgment relevant?
Your lordship,
Next judgment.
your lordship, the government has taken the decision on the basis of certain reports. Your lordship, the second part reflects, as complaints have been received at various levels. So reports are coming from the concerned PRI. So the withdrawal of the Jila Parishad order, it says that basis is the cabinet decision. Their foundation is the cabinet decision.
Now tell me, how can you insert a
Cabinet
viable rate?
decision itself taken on the basis of certain reports.
Understood, but how can the government decide on the viable rate? Out here, without amending rule 47? 47 does not say anything about a viable rate.
Your lordship, my learned colleague has referred to 243G, your lordship. Two 43G in the article. It says 243G clause B, the implementation of schemes for economic development and social justice as may be entrusted to them, including those in relation to matters listed in 11th schedule. So your lordship, in the 11th schedule, the item number 22 it speaks about markets and fairs. The issue here involved issue is here the settlement of markets. So the language used in 122 in the Assam Panchayat Act.
Where? Mr. Kumar, kindly see you are reading B without reading the first portion of 243G. It says, subject to the provisions of this constitution, the legislator of a state may by law.
Yes.
So where's the law? Law is where? In the table in the cabinet meeting.
Your lordship, the
Cabinet meeting cannot be law.
under section 122, your lordship.
No,
A,
Can
clause
the
A.
cabinet meeting be law? By law.
The law is in 122, your lordship.
By law, endow the panchayat with such powers and authority and may by necessary to enable them to function as institution of self-government, and such law may contain such law provisions for the devolution of powers and responsibilities upon the panchayats at the appropriate length subject to such conditions as may be specified therein with respect to the implementation of the schemes for economic development and social justice as may be entrusted to them, including those in relation to matters listed in the 7th schedule. So these will be there. Don't you think that there is a requirement of amending to insert the viable rate?
Your lordship, section 123 says, while we withdraw the power from the TRIs, we are not withdrawing any power from the TRIs.
You are not. But how are you inserting?
Section 122, subsection 1, your lordship.
Section
There
1
is
says
the
that
power.
notwithstanding anything contained, the state government can The fair subject to being national policies and state policies.
It's a matter of state policies, Your Lordship. It's a state policy.
So it being a policy decision,
Yes,
you have taken a policy decision, so this is there, and therefore you exercise going 120. That is your case.
yes. Your Lordship, the candidate, section 132, the Panchayat Act here.
Yes.
There is removal of difficulties.
Hmm. So what is your policy decision as per your affidavit?
This is page number 39 of my PPT. It is pertinent to state.
Mr. Bottom, have you seen the Assam rules of executive business? It was a cabinet decision. Huh?
Yes, it comes to cabinet.
So your submission is twofold. First, what right do they have?
Yes.
Because there is no right which have been accrued upon them.
First, it is a commercial transaction. Since it's a contract is a commercial transaction.
Your basic case is what right do they have? We have only made an offer to them that you are the highest bidder. And as such, there is a requirement of certain further formalities to be completed as in terms of Rule 47, 12 and 13. which have not been completed and there is no lease being executed till date. So, and there is no payments being made, so under such it is not fine. So under such circumstances, you cannot have any right to challenge or right accrued on the basis of that settlement order being passed.
It was just a proposal. Settlement proposal.
Second, it is just an intimation that you are the highest bidder and we are going to give you subject to doing this. Secondly, it being a policy decision of the government taken in a cabinet, it would come within the ambit of state policies. And as such, the power is there under 122(1). That's your case. How do you take care of the amendment issue?
Amendment issue. I have stated in my affidavit.
But your proposal to grant extension cannot be there.
Yes.
Cabinet may choose whatever may be, but the cabinet cannot amend the act or the rules. They may make a rule, it's a different thing. But the cabinet cannot, by way of an executive instruction, override.
Your Lordship, my submission is amendment is not required because we are not withdrawing any power.
No. To grant
Only there.
extension. How do you grant extension?
Your Lordship, so far as the extension part is concerned, Your Lordship, law is settled, Your Lordship. I'm not harping on. I'm on second part. It is settled law. Your
The extension you are not. So you are therefore the basic case is it being a policy decision,
Policy
it comes
decision,
with
second
the
part.
state. Where is the 27(6) policy decision? Because to become a state policy, is it only referred to panchayat or everywhere? This viable rate?
Your Lordship, what is the other department is? I have no.
No, it can't be. It is a,
But,
when it is a
this-
cabinet decision,
Yeah,
it's a
this
decision
cabinet
of the
decision
council of
speaks about the
ministers.
only the panchayat. This cabinet decision only speaks about the panchayat.
So can it be termed to be a state policy?
Your Lordship, so far as the zone behind this policy decision is that to give some solace to the vendors, small vendors and the consumers.
Your
I think-
idea may be right.
Right.
To the effect that,
Lordship,
okay, we are going
so
to have a
far as
viable
the
rate.
Other departments are concerned, that instruction is not with me.
No, the
can
policy
bring it,
decision, because it has been stated on affidavit that there was a policy decision on 27/6/2024. And it is on the basis thereof you have done this,
Yes,
isn't it?
yes.
So therefore, the question is, could you have, was it only limited to panchayat? Because it was a state policy.
In other departments also, if there is any commercial transaction, maybe they are. The settlement matters is involved in ferry guards, in there are inland waters. Therefore,
Take it up at 2, get that policy decision. Cabinet memo. That policy decision.
if also say in any other day, so
Ooh. Go for it.
I'll try.
Why otherwise you'll say that you failed to produce, we have given you, it was your duty. So that is the basis on which you have done. Why I had to ask you, because in your affidavit you said about a cabinet decision of 16/7/2024.
Yes.
Can there be a cabinet decision prior to, after the notification? We see your affidavit, what
But
you
if
have
the
said.
My humble submission is this: so far as policy decision, it cannot stop it. It cannot start on a auspicious day. At any day, in any moment, government take decision. If the larger public interest
Mr.
is involved,
Kindly understand what you are saying. Kindly come to paragraph 6 of your affidavit. So these, did the cabinet decide this without any basis or just did it?
Lordship, your lordship will file with page number 39 here.
No, come to 37. Your cabinet decision is 27/6. Notification is 29/6. The decision of the cabinet subcommittee is subsequent. So here in Assam, first the cabinet takes a decision and then the subcommittee takes a decision. I don't know. Does it happen like that? That is why I was looking into the Assam rules of executive business. That is not
No,
permissible.
no, your lordship, so far as subcommittee is concerned, your lordship, they will only look into the modified NIT conditions. Cabinet decision is there.
Read Mr. Court paragraph 6.
So lordship, here your cabinet subcommittee will look into the micro level.
So therefore, I wanted to see the cabinet memo.
So lordship, kindly see page number 39. The claims, your lordship, the last paragraph will kindly.
Yeah.
In the instant case, government in the PNRD department, Assam, after calling and pursuing the records and documents in possession or under the control of the panchayats, took a sound policy decision by notification dated so and so to cancel the ongoing process of settlement. So it is. There
Who
is
has taken the decision?
there is sudden.
Who has taken the policy decision?
Yes, your lordship.
Cabinet, a policy decision can only be taken by the cabinet. It can't be taken by your PNRD department.
Your lordship, the cabinet decision.
That is, that,
taken on
Mr.
27th.
Law, that is
Your
the
lordship,
law.
I'm sorry, your lordship, that this is the notification whereby we have cancelled.
Then why are you saying that you have taken a decision?
Decision is dated 27 June 2024. It was your lordship may kindly take up 3613 of 2024. WPC 3613 of 2024.
Hey,
Page
3613.
34. Item 14. your lordship.
Ask your junior to get hold of that cabinet memo. That is the only saving grace if you have. Yes, what is here?
Yes, sir. This is your lordship. Page 34, they have annexed your lordship cabinet decision details. Is probably downloaded from
The cabinet decision is here.
27 June 2024. Ongoing present. Twenty-nine cents.
So this is the cabinet decision.
Yes.
So, Mr. Bhattakur, if this is a cabinet decision, wouldn't it come within the state policies?
Lordship, it may be a policy, your lordship, policy decision, but it probably, your lordship, in my humble submission, it is not a state policy, your
It
lordship.
would be a state policy. The moment it is a cabinet decision,
Sure.
that is why I asked him. If it is a cabinet, I see the Assam rules of executive business. And if you also see the judgment of the Supreme Court in Supravat Steel, it's a very interesting judgment in that. What has happened out there? There was an industrial policy issued by the state of Bihar, granting various exemptions. One of the exemptions was, however, not given by one of the departments, saying that no, we are not given. Supreme Court say that the department can't do so because it is already a policy decision where all the cabinet members have already decided and come to a final opinion. And as such, a policy decision or a industrial policy which is on the basis of a policy decision cannot be taken out by some department. He has written out there that it is the PNRD's decision, it's a different thing. It is actually a cabinet's decision. Once it is a cabinet decision, it is the policy decision of the state. And if it is a policy decision, why not 122.1 will come into the picture?
Lordship,
Power is there.
lordship, the power is there, your lordship. At the end of the day, your lordship, so far as this merit of the cabinet decision, we have not questioned it, your lordship. They can, your lordship, at any point of time, take a decision. But our only case is this, your lordship, that while implementing this decision, you will have to follow the procedure prescribed law, your lordship. And that will be, your lordship, by bringing an amendment to the provisions of the Assam Panchayat Act, the rules framed there.
Which they may do.
Yes, sir.
No,
Once
which they may do.
Once they
But
do that,
can't they, under 122.1, in view of it being a policy decision, it being a state policy, issue directions to the panchayat that don't go forward. It is a question of jurisdiction and authority. They have the jurisdiction and authority in view of the fact that it is a policy decision, state policy. Whether they are going to amend the rule 47 or not to insert the viable range is something in future, which they will do it later on. Which they will do it.
once they do that, your lordship, then your lordship, then if it comes, your lordship, in the
Because there will be not only that amendment, but tell me, if this is a policy decision out there, which obviously may require later on, that for insertion of a viable rate or not, which will be a subject matter of a question in another litigation. But here, the fact that they had the authority and the policy decision not being challenged, can this court hold that the action of the notification is bad?
lordship, in my humble submission, your lordship, with section 122, your lordship, we will have to see the purpose for which this act has come, your lordship. It is essentially for decentralization of power, your lordship, and taking decisions by at the lowest rung of the administrative unit, your lordship. That is the panchayat, your lordship. Now, if your lordship, government can, by exercising power under section 122, in the name of policies, allowed to interfere in the functionings of the panchayat, then the very object for which these legislation or these panchayats are established, these institutions are established, that will become redundant, your lordship, and that will make, your lordship, that they again will have to depend on everything on the state government, your lordship. If that,
No,
and that is why, your lordship.
But for that, the panchayat is not before us.
No, that need not be, your lordship, but ultimately, your lordship will have, even if the panchayats are not there, your lordship, then also your lordship in my humble submission will have to look into that respect. And your lordship 243ZH, your lordship, H is very clear, your lordship. Therefore, your lordship, when it is by your lordship, act of the legislature, your lordship, this power has been given to the panchayat, your lordship. If you want to tinker with any of it, your lordship, they will have to, your lordship, go by the legislative mode, your lordship. Only then, your lordship, the mandate of 243H will be complied with, your lordship. That is why, your lordship, it has
Why are you saying by legislative mode?
because, your lordship, the legislature of a state may by law, it says 243H, authorize a panchayat to levy, collect and appropriate such taxes, duties, tolls and fees in accordance with such procedure and subject to such limits. Everything is there, your lordship. Limit,
Levy, collect and appropriate such tax so and so assigned to person. So this is okay,
lordship.
but the legislature, are you saying that the legislature, the Panchayat Act should include everything?
Not included everything, but your lordship will kindly see
Then what about the financial rules? Financial rules is made by whom?
by this
Not
under
by the
the
legislature,
statute
by the state government.
government, under the statute, your lordship,
Understood, by the state government.
state government,
So it is not by the legislature.
lordship.
So if the financial rules can be made by by the state, which is duly empowered, why can't the state, by way of an executive instruction, insert, which is something which is not contrary to it? Yes, for the purpose of extension, they can't, because they cannot be an extension.
Right.
There's no quarrel with that. But to insert the viable rate, why not by way of an executive instruction that can be done? And whether it is done or not, that is another question.
Lordship.
They come later on.
That
In
is
another proceeding when they insert it, that they can't. But as of now, their policy decision is for taking care of all the small traders. We want to do one thing, cancel all these tenders and put a viable rate in these tenders. And as such, we cancel it. This is the policy decision. This is the policy of the state. Why can't 122(1) come into it? Because there is no violation to that effect. The power is there. The power has been given. The power to levy has been given. Everything has been given. The manner in which it is to be done is by the rules.
rules, your
And the
lordship.
rules are made by the state government.
Absolutely, your lordship. But
And
your,
therefore, the state government can, by way of an executive instruction.
no, your lordship, in that, your lordship, I have your lordship, I am submit your lordship 105, your lordship with see your lordship will see to detailed procedure for
Mr. Gotanga, just I'll come back.
No.
5 minutes. Yes.
lordship so far as my submission to that your lordship with power section 122 will be your lordship. If we interpret 122 your lordship without looking at the object of the act itself, your lordship, that probably will not be proper for this honorable court to give that power to the state government, your lordship, which in fact not the intention of the legislature, your lordship, either parliament or the state legislature, your lordship. And therefore, your lordship, when we talk about state policies, your lordship, that cannot be in the nature of this, your lordship, and that state policy will have to be considered, your lordship, under 243Z, your lordship, B, your lordship. Policies regarding implementation of schemes, etc., your lordship. Where, your lordship, that has not been, the no, legislature has not prescribed any procedure, your lordship. In those cases, your lordship, those policies, your lordship, can be, your lordship, directed to be implemented in a particular manner, your lordship. Where there is a specific set of rules, your lordship, prescribing a procedure as per the act, then, your lordship, that procedure can be changed, your lordship, only by way of an amendment to the rules or the act, your lordship. Ultimately, your lordship, executive order, cabinet decision and executive order is also a law, your lordship. But at the same time, your lordship, when this is a covert area, your lordship, by the legislature itself, then probably your lordship be doing that by way of an executive order, your lordship.
But section 122(1) starts with a
Lordship,
non-obstinate
lordship,
obstinate clause.
lordship.
Then
But your lordship, that is why your lordship, I am submitting your lordship in the by interpreting 122 with the help of non-abstention clause, your lordship, that it gives wide power to the state government, your lordship. That will ultimately, your lordship, that open a door for the state government to interfere with the affairs of the panchayat, which is not the intention of the either of the parliament or the legislature, your lordship. And that is why, your lordship, 243 GI is very clear that state legislature by law, your lordship. It would have been by law itself, your lordship. That has not been done by the parliament, which says your lordship, state legislature by law. So therefore, the mandate is by the state legislature or the legislative power exercised by the
understood. This is understood. But then also by state legislature, by law made by the state legislature, 122 has been inserted, giving a non-obstinate.
lordship.
See, one have to have a fundamental, understand the fundamental difference between a state policy or the national policy vis-a-vis a policy decision.
Lordship.
A state policy is a policy derived from the directive principles of the state.
Lordship.
And the basic idea is that everybody out there should be given equal opportunities. That is one of the state policy, directive principles of state policy. And here, if you see that, therefore I asked him for the cabinet decision. The cabinet decision is the state policy. The 29(6) is the policy decision by which we are implementing the state policy. So this is how you are doing it, showing that, okay, you cancel the standards and we are going to go for this, inserting this, which is now the state policy, basing upon the directive principles of state policy. So if that is so, how can this court interfere and say that it would not come within the ambit of 122?
Lordship, my
When the wisdom of the cabinet decision has not been put to challenge.
no, your lordship, we are not on cabinet decision. That is, they are well within their power to take that decision. Your
So
lordship.
then it becomes a state policy.
No, your lordship, that is your lordship, with utmost humility in my command, your lordship, I beg to defer your lordship, submit that your lordship, there are a lot of policy decisions taken by the government. Will every policy decision will become state policy, your lordship?
No,
That is why, your lordship, this when
no. Therefore, that is the fundamental difference. You cannot have a policy decision without a state policy.
lordship,
The state policy is, as per the cabinet's memo, is that we are going to give equal opportunities to many persons. Certain people are taking a huge amounts, quoting so such huge amounts, and thereby the small traders have been taken out, which affects actually, although in not many words, actually the directive principles of the state policy. So we want to follow in terms of the Article 39, we are giving that this is our state policy. Now, the policy decision, which is also there, that there would be certain directions be issued to the what you call the PNRD to set out the modalities, how it can be worked out. Now, these modalities, how it is to be worked out, is to be inserted out there in 47 by amending 47 or not by that is another aspect. But this is a policy decision. The first part is a policy decision.
no, your lordship, it is a policy decision, no doubt about that, your lordship. I have no quarrel with what has been
But
submitted
if
by
you
the
say, yes, such policy decision which is being taken could not have been even a state policy to that effect, taking into account the directive
that is
principles
what
of the
your
state
lordship I am
policy.
submitting. That it is your lordship, since your lordship, it when to be a state policy or the national policy, your lordship, it will have to be as envisaged in the your lordship, the directive principle of state policy, your lordship. It will have to be, your lordship, and that is not there in this particular policy.
Why?
No, your lordship will kindly see the directive principle of state policy.
Yes.
Your lordship.
38.
38 euros. Social order for promotion of welfare of the people. Certain principles of policy to be followed by the state 39. That the citizens.
38.1. The
39.
state shall strive to promote the welfare of the people by securing and protecting as effectively as it may a social order in which justice, social, economic, political shall inform all institutions of national life. The state in particular shall strive to minimize the inequalities in income and endeavor to eliminate inequalities in status, facilities, opportunities, not only amongst the individuals, but also amongst groups of people residing in different areas or engaged in different vocations.
Lordship.
Why it won't come under 38.2?
Lordship, 38 to your lordship, it essentially your lordship, it says about inequalities of.
This is the basis. Kindly see the cabinet memorandum which is
Lord.
there. It categorically says this is why it has been done. In view of concerns received from various quarters and this resulting in higher rate of so and so and have decided to cancel so and so, will float so and so, any bidder and so, any highest bidder in so and so.
Not more than that, your lordship.
See, this will benefit the common people by bringing down the prices of commodities being traded in such designated area.
That is your lordship, they probably your lordship, they in the intervening period till new tenders are issued, the bids are made, the present lessee will continue to run these markets at previously settled rates. This will benefit. This means your lordship, the probably your lordship, second part your lordship, that the continuation with the earlier lessee.
Absolutely no.
Yeah, but your lordship, word used in such a manner, your lordship, it gives an impression that your lordship, this has is referring to that, your lordship. I don't know, your lordship, but had the been there, your lordship would have been in the first line itself. That as it be that as it may, your lordship. But my submission will be, your lordship, this is a policy decision, no doubt about that, cabinet decision. But that will not be a state policy or national policy as such, your lordship, as envisaged in section one
The
twenty.
policy decision is based upon the state policy to have equal, because these the small traders and all should be given equal. Why won't this will come in 38 to strive and minimize the inequalities in income and endeavor to eliminate inequality in status, facilities and opportunities and not only amongst the individual but also amongst a group of people residing in different areas or engaged in different.
Now, your lordship, when government brings in, your lordship, minimum wages act, your lordship, that is, your lordship, the purpose is to achieve this goal. Your lordship. That the various vocations, your lordship, people are there, your lordship, minimum wage, living wage, they should get, your lordship. But your lordship, that impacts a huge number of people in a country like India, your lordship. Now, your lordship, if this we relate, bring it to this, your lordship, probably your lordship, that is not the intention, in my humble submission, your lordship.
And the idea behind the state is, I mean, if you have a huge prices in the panchayat area, means they quote a huge amount of money to get the, yeah, first of all, they leave halfway. And the second is, with this huge amount, they will be asking that money from those vendors. And the vendors automatically has on to pass on to the people. And the people are therefore the sufferers.
Now, your lordship will kindly see, your lordship. I have not argued on that, your lordship, because your lordship, we have not put that cabinet decision to challenge. But my friend has challenged it. But your lordship may kindly see section 95, your lordship. We cannot on our own impose, your lordship, prices, your lordship. Taxation. subsection 3.
Yes.
Ultimately, your lordship, we impose on the basis of the rate prescribed by the panchayat, your lordship. It is not, or by the government. Your lordship.
No, no, subject to such maximum rate as the government may prescribe.
Lordship,
The government will prescribe a maximum rate.
lordship. That is why, your lordship. Subject to maximum as government may prescribe, Jila Parishad may levy tolls.
So the levy of toll by Jila Parishad is subject to prescription of a maximum.
Lordship, that's your lordship, that is
Now
what,
the government wants to prescribe the maximum rate.
no, your lordship, that will not be the maximum rate. Your lordship. Toll, your, ultimately, your lordship, the cabinet decision says, your lordship, as has been following from your lordship, mouth, your lordship, that since we quote a higher rate, then we started to take exorbitant tolls from the people. That is probably not correct, your lordship. Since, your lordship, the toll we impose is prescribed by the panchayat itself, your lordship. Therefore, your lordship, the taking of toll, your lordship, has no relation with the price we have quoted, your lordship. That's what my submission is, your lordship.
How will you recover?
Lordship, we are,
How will you
your
recover?
lordship, in that case, your lordship, that being an astute businessman, your lordship, we know how to recover, your lordship. In fact, by
Understood.
quoting,
So exactly what you are saying is in Datta Associates,
so your lordship,
being an astute businessman. So Datta Associates also say that there is a requirement of fixing a viable. Without fixing a viable, you cannot, because you will know how it is to be done.
lordship,
So therefore, now they are trying to have a viable rate, not more than 10% of the last 3
with
years.
no objection. We have no objection at all.
And
Our objection is to your lordship, you have initiated a process. That process has actually attained finality, your lordship, by executing an agreement also, your lordship. You offered me settlement.
has anybody paid the amounts? They paid the amount. Agreement?
I was operating for nearly 2 months.
Huh?
Nearly 2 August 21, they canceled.
You were operating for 2 months. Yes, why have you done this? Item number? Then they would not come within the ambit. of 20.
126.
How can you cancel already when you were operating for 2 months? You can't
Your
cancel
lordship,
that.
I'll have to examine it.
And my lord, the rate which was quoted was similar to the previous year's rate.
Huh?
The rate which I quoted is the same to the similar to the previous year's rate, the previous bidder's rate.
It's okay, but you were running.
Yeah, I'm saying.
Your lordship,
On page number 36,
your lordship, page number 8 of his petition, paragraph 4. Lordship, the cabinet decision was taken on.
No, your period will start from 1/7.
1/7. Your lordship.
Then how are you? You are same.
and yes, same,
Yeah.
but I was settling because my first offer was given on 26/6/2024. So and thereafter I deposited the deposit, then the,
Oh, that you also-
and then this notification came on 29 May.
By this time, the petitioner had deposited
And I have deposited to
Yes.
month's kist also. My lord. I have
for the
decided
month
this.
of July 2000 you are on demand. So this was after this.
Yes.
They could not have received it. Oh, this cannot be the basis of the right.
In my cases, your lordship, only agreement was
And then also you were running for 2 months.
Yeah, man. Then they issued notification, my lord. And then
Huh?
then the letter was issued on 21st August 2021, my lord. Page number 48. Qualification.
Yes.
Then from that date I was cancelled.
This happened because of this. The stay. You got.
Yes,
You were running the problem. All this happened because you got a stay, na? You had a earlier lessee.
No, earlier Messi died.
So you were asked to continue for some time.
No,
Earlier, no.
no, the fresh tender was, I got a fresh tender.
So your situation is same. You were running, you were lucky to run for 2 months. Mr. Botago's order did not percolate there to that Murigaon person.
And one more thing, Your Lordship, that's apart from what I have submitted on the point, Your Lordship. The ground, Your Lordship, for rejection of tender, Your Lordship. Ultimately, Your Lordship will kindly see 4711. On acceptance of the tender, the concert concerns shall inform the selected tenderers concerned requiring the tenderers to submit within 7 days from the date of issuing the acceptance letter to one, deposit the concern not less than 30% of the quoted amount of this tender security. The amount of security shall be recorded in the register. This is not required. Then the concern shall provide the form of lease and stamp papers in the concert lessee's cost. If the tender referred to in subclause 2 fails either to deposit the required amount or to accept the lease within the stipulated period of 7 days, the concern shall refer the matter to the government whose decision in this regard shall be final. Now, once tender is issued, settlement, Jilla Parishad has decided to settle it with me, and that is communicated to me. Thereafter, only on this ground, only can my settlement be cancelled or your lordship refer to the state government, your lordship. Here is a case, your lordship, in my both the cases, in one settlement order has been issued and another settlement order is issued, then your lordship agreement is executed. Thereafter, your lordship, there is no failure on my part, your lordship. Had there been failure on my part, then they can, your lordship. But that not having been there, your lordship, probably your lordship,
When was the agreement issued?
your lordship, in the second case, your lordship, agreement was declared. First of July, your
So after 29, it
Lord,
could not have been done.
lordship.
Could not have been done by them. And when when they have come up with this, when there was already a direction issued by on the basis of a cabinet area, agreement entering was wrong. So therefore, entire thing hinges on 29.6.
Lords.
29.6 is held to be good. Then nothing remains. All
Lord.
has to go.
If your
All
lordship have
other rights will flow. As to whether there is a requirement of an amendment or not. These are questions which will be looked into later on. You may challenge it again. Well, let me dictate.
lordship, he wants to.
Yes, what do you have to say?
My item lordships 18. I have challenged both cabinet decision as well as the notification. And the submission is that lordship, since the government has fixed the rate, the government will suppose to the 5 lakhs. Every bidder has to ask to deposit, shall not entitled to deposit more than 10%. Suppose everybody will quote 5 lakhs 50, so how they will select? There is another question. It will be pick and choose basis. Since they have been fixed the rate and maximum 10%, everybody will quote the same rate. That is also not permissible as per tender system. And the submission is that lordships. After the game is over, rule cannot be changed. They have to done it prior to that
Where is the game over?
because tender was system completed. Persons offered their rate. Some of them also got the market lordship.
Market they have, but they have not been able to enter into anything.
Whatever maybe rule can be changed prior to that. But end of the day, in the meantime, this is over. I am the highest bidder. Somebody statement is also, PPR.
That's why let us take the example. You are the highest bidder in a particular contract.
Yes,
Tomorrow the government wants to cancel the tender. Can they cancel the tender? Forget about this. Otherwise, law
otherwise, Lordships,
clearly says that the government can cancel the tender for
they
good
have to
reasons.
done it prior to that, Lordship, even. And even that since they
There
have,
are many cases we find wherein the lot of persons who are there, I'm the highest bidder, but the government have cancelled it for vested reasons that they want to serve some benefit to some other person.
if
Yes,
my
in
tender
those
was,
cases, if the court sees from the records, yes, this is the case out there, court may interfere.
if my amount is exorbitant, then they can have the power as per law.
No, 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 no. The fact that the government can cancel the tender, a person who issues the tender can also cancel it. Now, pursuant to the directions passed by the PNRD department in that notification, which is the subject matter of challenge, orders have been issued to the effect that the tenders have been cancelled. This is also a subject matter of challenge. Now, if a decision has been taken by the government that you are to cancel everything for good reasons, can the court interfere under 226?
As per policy,
Unless it is arbitrary or unreasonable, the power is less.
yes, certainly power is there, Lordship. But without
Unless you show,
amending the
yes,
rule,
in certain cases, there was one case I remember, was it your case? Where I held it, that we could not have cancelled it in this manner and directed them for your case.
Yes.
But there has to be some materials to show that yes, this government who have done it or directions which have been given to cancellation was wrong.
here
It
is
was
the
illegal and arbitrary. Show me that.
because without amending the rule also, Lordship.
Again, rule is different. Rule will come later on. For that, they are having a select subcommittee.
Only reasons there is a various complaint received, persons exorbitant amount, that's why Lordship cancelled. But here they have the power. Election is on their part, Lordship. They have to select whether it is exorbitant or compare the government value or not. Here is the rate also, for all the everybody quoted their rate. Government is the power, who will be the best. If it is exorbitant, then can cancel highest bidder. That is also the rule saying. My case also not exorbitant. And also not it is maximum 10% also. And since they have fixed the rate, how it will be settled? There is another question. Everybody will quote the same rate.
There are many tenders which are settled in that manner only. They have a viable rate given. So somebody gives points and point. Think about these points. And if you put the maximum, which is also given in the cabinet decision, you see, R&D department will decide the modalities for selection of the hire in case two or more bidders quote the same price. Then decide. Whether they decide wrongly, will come again back before this court.
It will be pick and choose basis. Every document will also be found correct.
Good.
That will be,
There will be more
also
litigations
be an
for us.
arbitrary.
But there are many tenders wherein the maximum rate is fixed. There are many cases where maximum rates are there. Then also there are other parameters which are looked into. This is how it is being done. This is how it is. They will have to mention it. In view of doctor associates, they will have to mention it. And many tenders are there where they mention it.
That has not been
So
mentioned.
they may have a draw of lots. Which these BPL has.
Now it is
BPC.
going to see also.
Everybody has a draw of lots.
Here is not
Go for a
mentioned in the
local.
policy decision.
Everybody is putting the same go for local. So these are all not within the realm. The realm is as to whether it is good or bad. Anyways, let me disclose.
My,
Kindly,
Senator
Your Lordship, I am relying on a judgment.
Yes, yes.
Section 122 euros, by 2017, 10 SCC 713 euros. We are also waiting from. I will have
2017,
10 SCC 713 euros. Para 27, 3. Para 27,
2017, NSCC
713.
713.
Relating to land acquisition. Para 20. May I read you?
I was having this, today I have kept all matters without any acquisition proceedings. Last I've again come back to an acquisition.
Only one paragraph.
Yes.
On interpretation.
Yes, para?
27 euros. Interpretation must depend upon the text and the context. We are the basis of interpretation. One may well say if the text is the texture, context is what it gives the color. Neither can be ignored. Both are important. The interpretation is base, which makes the textual interpretation match the contextual. A statute is best interpreted when we know why it was enacted. If the statute is looked at in the context of enactment, which classes of the statute maker provided by such context, its scheme, the sections, clauses, phrases, and words may take color and appear different than the statute is looked at without glasses provided by the context. We must look at the act as a whole and discover what each section, each clause, each phrase, and each word is meant and designed to say as to fit into the scheme of the entire act. No part of a statute or a word of a statute can be construed in isolation. This is your words. Section 122 will have to be interpreted, Your Lordship, in the context in which the act has come, Your Lordship. This is my submission. Lord, that much.
Heard Mr. S. Bhuttakur, the learned counsels. S. Bhuttakur. Give all your names, huh? The learned counsels appearing on behalf of the petitioners in the instant batch of petitions. I've also heard Mr. A.K. Paul, the learned, yeah, additional advocate general,
Yes, sir.
the additional advocate general of the state of Assam, who also is the standing counsel of the PNRD department. In addition to that, on behalf of the PNRD department, Mr. S. Doctor, and nobody else. Who?
A.K. Ghosi.
Yes, on behalf of the PNRD department. Ms. Swenso and Swenso represents the private respondents in the petitions. There are two false challenges in the instant batch of petitions. We segregate the 39. 13 is whose? Yours is 13. Yours is different. You won that policy decision, didn't it? We segregate that. 13 to beside you. Huh? The instant batch of writ petition have been filed challenging the challenging primarily the decision, the notification dated 29/6/2024, issued by the Principal Secretary to the Government of Assam, Panchayat and Rural Development Department, whereby the ongoing process, ongoing process of settlement of the Ghats, Bleak Ghats, fisheries pounds for the year 2024 and 25, which were for which NITs were floated, were cancelled on the basis of a decision of the cabinet dated 27/6/2024. In addition to that, in some of the repetitions, the cabinet decision dated 27/6/2024 have also been assailed. The petitioners have also sought for a writ in the nature of mandamus, seeking directions upon the authorities concerned to bring the tender process to a logical conclusion by allowing them to run the settlements. For deciding the issue involved in the instant petition, this court, for the purpose of this court would like to deal with the facts primarily which led to the filing of the writ petitions. The materials and report reveals that these are all various tenders, na? Or one tender?
Various tenders.
The various Anchalik Panchayats, various Anchalik Panchayats under the Assam Panchayat Act 1994 had issued notice inviting tenders for settlement of various tenders. All same date?
Different it.
Huh?
Different it.
Have issued settlement, notice inviting tenders for settlement of markets, ghats, fisheries. Pursuant to these notice inviting tenders, the petitioners herein, along with various other bidders, participated in the said bid process. And were informed, respectively, that their bids were accepted and thereby asking the petitioners to submit to do the needful in terms with section rule 4711 of the Assam Panchayat Financial Rules 2002. While the said process was going on, A notification was issued on 29/6/2024 by the Principal Secretary to the Government of Assam, PNRD Department, PNRD Department, informing all concerned that pursuant to a cabinet's decision held on 27/6/2024, the governor had cancelled the ongoing process of settlement of carts, fisheries, ponds, etc. for the year 2024-25, for which NITs were already floated. In the said notification, it was also mentioned that until new tenders were finalized, the existing lessees may be given extensions at the settlement value fixed for the year 2023-24. In addition to that, it was also mentioned that the basis for taking the decision was on account of certain complaints received at various levels that the small traders, vendors, and other sellers in the huts and bazaars, etc., were often exploited by the bidders who quote exorbitantly high bid price to grab the lease. And as such, the governor of Assam was pleased to make provisions that no settlement shall be made with the bidders who quote more than 10% of the average settled value of the last 3 years of these ghats, huts, fisheries, public pounds, etc. Also, on the basis of that, new NITs would be included, would be issued, which will include these conditions and would be floated for settlement of the huts, fisheries, pounds, etc. for the year 2024-25. On the basis of the said notifications, the petitioners herein were on the basis of the said notification, various office orders were issued by the Jila Parishads, thereby cancelling the entire tender process, as well as also, and in some cases, the tendering the tender process. Being aggrieved, the petitioners have approached this court by filing the various petitioners have approached this court by filing this batch of writ petitions. In the backdrop of the above facts, let this court now take note of the submissions made by the learned counsels appearing on behalf of the parties. Mr. S. Potako, the learned counsel, appearing on behalf of one of the petitioners, submitted that Section 105 of the Panchayat Act 1994, for short the Act of 1994, stipulates how settlements of huts are to be made by the Anchalik Panchayat. Referring to subsection 2 of section 105, the learned counsel submitted that the detailed procedure for inviting and submission of such tenders shall be as prescribed. And in that regard, referred to Rule 47 of the Assam Panchayat Financial Close Rules 2002, for short, the Rules of 2002, whereby wherein the procedure for sale and settlement of markets, ferries, fisheries, and ponds have been stipulated. The Learned Council further referred to that these settlements shall be made subject to the confirmation of the Jila Parishad, and in his cases, in respect to the petitioners for whom he represents, the Jila Parishad had confirmed such settlement. The Learned Council further referred to Rule 47 and more particularly submitted that the interference in the said tender process by the government would only arise when a case comes within the ambit of Section 100(5) of the Act of 1994, or in a case coming within the ambit of Rule 49(9), sub-rules 9, 10, 12 of Rule 47. The Learned Council further referred to the provisions of the Constitution, more particularly Article 243 G and 243 H, which stipulates that the state that the, it is that the powers, authorities, and responsibilities of the panchayat, as well as the power to impose taxes by and the funds of the panchayat, have been already stipulated under the Act of 1994. He submitted that in view of the he submitted that the Constitution 73rd Amendment Act 1992 was enacted, thereby inserting Part 9 to the Constitution of India, so that the decentralization of power so that the panchayats are empowered and enabled to function as institutions of self-government. The Learned Council therefore submitted that in view of the mandate of the Act of 1994, as well as the rules framed therein under, read with the constitutional provisions as stipulated, as mentioned, as contained in Part 9, Roman 9 of the Constitution, interference of the state government is minimal. Else, it would make the amendment to the Constitution nugatory. He therefore submitted that when this court is dealing with the instant proceedings, this court has to interpret the provisions of the Act of 1994, taking into account the intention of the legislature in bringing in amendment of the in amending the constitution, thereby inserting part 9, as well as also the act of as well as also the basis on which the act of 1994 was enacted. Pushkar. The legal counsels were submitted that such interpretation if not made, and if the interpretation is not made in such a manner, it would result in undue interference by the state government and undue interference of the state government in all matters, and resultingly the object behind the amendment to the constitution would and as such the object behind the amendment of the constitution about decentralization of power and permitting the panchayats to function as institution of self-governance governance would be nugatory will लिखे हो खाली change the word. The legal counsel referred to the judgment of the Supreme Court in the case of State of Maharashtra versus Reliance Industries Limited, reported in 2017, 10 SCC, page 713, and more particularly referred to paragraph number 27. Pusto. Mr. So-and-so, the learned counsel, the learned counsel appearing on behalf of some of the petitioners submitted that the petitioner have challenged, not only challenged the notification dated 29/6/2024, but also have challenged the cabinet decision. He submitted that the cabinet decision which was made would only result in more arbitrariness and unreasonableness, inasmuch as when all bidders quote the maximum permissible viable rate, it would result in pick and choose policy. Anything more? Sure. Mr. The remaining councils, Mr. So and so, have also made similar submissions. But for the sake of brevity, this court is not repeating the same. Per contra, Mr. Kekor, the learned additional advocate general, Assam, submitted that the power exercised, submitted that the petitioners have no right to challenge the notification dated 29/6/2024, inasmuch as no rights had accrued upon them on the basis of being informed about the acceptance of their bid. He submitted that in addition to the acceptance of the bid, there are other formalities which are required to be performed, and in absence thereof, there is no concluded contract. The learned counsel submitted, therefore, the learned counsel therefore submitted that in absence of a concluded contract, no rights have had accrued upon the petitioners to challenge. In addition to that, he submitted that merely being a highest bidder would not confer any right to get a settlement. First, the legal counsel further submitted that the res- respondent state, the state of Assam, keeping in tune with the directive policies of state, directive principles of the state policy, and more particularly Article 38 and 39, have taken a had made a policy, had made a state policy to the effect that state policy, taken a state policy for the benefit of the common people, thereby to insert a viable range within which the tenders could be accepted. He submitted that this state policy had to be made, taking into account that the small traders, vendors, and other sellers in the huts and bazaars, etc., are often exploited by the bidders who quote exorbitantly high bid price to grab the lease. He submitted that these, further to that, in order to benefit the common people by bringing down the price of the commodities being traded, it had become a necessity that a viable range had to be incorporated in the tender documents. On the basis of the said, on the say on that basis, also, a decision was taken by the cabinet on 27/6/2024. The said cabinet decision was then notified by the impugned notification dated 29/6/2024, whereby to cancel the ongoing process of settlement of huts, ghats, fisheries, ponds, etc. for the year 2024-25. Mr. K. Kumar, the learned additional advocate general, further submitted that this power, the power so exercised, is in terms of section 122(1) of the Act of 1994, taking into account, and inasmuch as whereby the state have been empowered to issue directions to any panchayat in matters relating to state and national policies, and such directions were binding upon the panchayat. He therefore submitted that it now being a policy decision of the state to have a viable range in order to protect in order to protect the exploitation from exploitation to the bidder, to the small traders, vendors, and other sellers. The panchayat is bound. But panchayats were bound. The state had the power to issue such directions. Okay, let me come back to don't pay, interest will keep on accruing.
Sure,
If they
sir.
don't receive it, interest will
Sir.
accrue.
Yes, sir. Sir, we'll clear in a week, sir. Not more than week.
The instant we dispose, will we dispose it of?
Oh, my God.
The Deputy Commissioner, Dhemaji, Mr. So-and-so, is present pursuant to the order passed by this court on 18/11/2024. He has assured this court that within a week's time, the said payment would be released to the petitioners. Thus, taking into account the above, list this matter again on 29th of November 2024. Just for an update. The personal appearance of the Deputy Commissioner I dispensed with. Okay, Miss. You
Thank you, sir.
release the amount within this week, next week.
Sure, sir.
My Lord,
Thank you, sir.
in this matter, my Lord, total award amount is 3 crore 94 lakhs, my Lord. And thus, they paid, now they pay, are going to pay, 1 crore, 4 lakhs 68,000, my Lord.
You take that amount, the total amount as per the award is how much?
3 crore 94 lakhs, my Lord.
Then why they are paying less amount?
As per my instructions, Lordship, we have already, another 50 lakhs has already been sanctioned, financially sanctioned. But since we have not received.
You
the
said
same-
to me yesterday
Yes.
that the amount has already been deposited with the DC.
Yes, Lordship, 1 crore 4 lakhs has already been.
No, what is the
deposited.
awarded amount?
Our award is 3 crore.
Then why you haven't you paid the entire amount?
Because of the finance, because we don't have the.
Then why have you taken the it's land acquisition?
No,
Return the land.
We will be paying the amount, whole amount, Lordship.
When?
Lordship, in this year financial, means our budget proposal is only for 1 crore 50 lakhs. Lordship. And that.
No,
amount-
that can't be. How can you have a project without having your sanction, financial sanction? Without getting a financial approval estimate made, how can you have it?
That has already been done in the year 2000, prior to 2018, Lordship.
So what? There is a direction passed by this court. Not done.
As per order 79/2024, my Lord, the court directed to pay the full immediate.
You said you said that you have deposited the entire
Yes,
amount.
we have deposited 1 crore 4 lakhs. Lordship. As we get in the last court order. Lordship.
This can happen like this. What is the direction? Complete the exercise under the provisions of demand and disburse the assessed compensation amount to the in an expeditious manner, but not later than 6 months from the date of receipt of a certified copy. Now, how much is the award?
3 crore 94 lakhs, my Lord.
How do we know? How do we know that it is 3 crore 93?
In a earlier order, my Lord, dated on 9/9/2024, my Lord, the learned council submit that as per earlier order 9/9/2024.
So, Mr. So-and-so, the Deputy Commissioner Dhemaji is present pursuant to the order passed by this court on 18/11/2024. Full stop. This court had inquired as to why the amount have not been released. Amount of rupees 1 crore 4,68,600 and 850 have not yet been released to the petitioners. Mr. So-and-so, the deputy commissioner, submitted that the amount will be released within a week. Mr. Arendas, the learned counsel appearing on behalf of the respondent number 2 submitted that Ms. So-and-so, the learned counsel appearing on behalf of the petitioner, submitted that the total assessed amount is rupees 3 crores 24 lakhs 85,758 and only an amount of rupees 1 crore 4 lakhs 68,850 have been released by the Water Source Department. Mr. R.M. Das, the learned counsel appearing on behalf of the respondent number 2, submitted that the total amount that the said amount, the entire amount have not yet been sanctioned. And as such amount could not be released. This court duly takes note of the order dated 15/5/2023 passed by this court in WPC number 4825/2018, wherein there was a direction for expeditious payment for making a fresh assessment in terms with the right to fair compensation amount dated 2013 and to disburse the said amount within a period of 6 months from the date of receipt of the certified copy. The certified copy was received on 25/5/2023 and more than 1 year, 4 months have elapsed. 4 months, 5 months, 6 months have elapsed. But till date, the entire amount have not yet been paid, sanctioned, they have not yet been sanctioned by the Water Resource Department. The said action on the part of the Water Resource Department in not sanctioning the said amount and disbursing it to the Deputy Commissioner, the entire amount, and disbursing to the Deputy Commissioner, prima facie appears to be in contrary to the directions passed by this court on 15/5/2023. Accordingly, this court gives an opportunity to the respondent number 2 and to submit a reply as to why contempt proceedings should not be initiated against him for willful and deliberate violation to the order passed by this court dated 15/5/2023. This court fixes this matter on 29th of November 2023, by which time the reply be filed by the respondent number 2. The Deputy Commissioner, Dhemaji, who is present in the court, is directed to release the amount of 1 crore 4 lakhs 68,850 to the petitioner within 1 week from today and provide an update on the next date so fixed. I'm We'll see the reply on 29th, and then we will initiate contempt against him.
May I submit also?
No submissions, nothing. We are not concerned. Next, then, who is appearing for the chief secretary?
I'm-
Who is appearing for the chief?
I'm-
We are appearing for the chief secretary. Okay. Directed to both the chief secretary and here. Chief secretary and the water resource. Number 2 and 6. They both of them let them file and we initiate contempt against him. Why contempt proceedings should not be initiated? Till now, we have only issued a notice. It's not an initiation of contempt proceedings. Then we'll pass over appropriate orders. We have already come to a prima facie opinion that there is an apparent violation, a willful and deliberate violation.
We have the proposal as.
I'm not concerned with approval here. You are director. Why do you take land of people? If you don't have the money, one should cut their cloth according to their size. You don't have the money, don't take it. I hope you understand. Now, have you understood the judgment of the Supreme Court, the latest judgment? These doesn't come within the material resources of the state. So you don't have the powers of eminent domain to take whoever's land it is. Then if you take the land, you have to compensate. And if you don't have the money, don't do it. Return the land. Now the philosophy that the public good has to be taken into account, that has gone for a 6.
Yes.
Then
Yes, sir. New project, we are just abandoning the.
I'm not concerned about your new project.
Yes.
Why you are not paying the petitioner? The petitioner is entitled. Petitioner's land was taken when?
8 minor,
2010.
8 minor,
8.
2008.
8. Then who is going to pay the compensation? And not only that, how are you doing it? Interest? Who is paying? Who is paying the interest? Show me the detail as regards the awarded statement. Show me how did you arrive at 3 crores 4 lakh? I think this has to be further added. He's entitled to compensation, the interest at the rate of 80% as per section 80. Who is going to pay? Is the chief secretary going to pay that amount? You are paying for whom? How many petitioners?
6 now.
Tureswar Soikia, Moneswar Bhuya. Who are your petitioners?
Minor,
What are the names of the petitioners?
Mr. Soikia, Moneswar Bhuya, Khogen Chutia, Akhil Soikia, Potmo Bhuya, and Soroti Bhuya.
And how is he going to pay this for 1 crore 4 lakhs? Yes, Mr. Deputy Commissioner, how are you going to pay that? If only a part has been sanctioned given to you. Because there are many petitioners who are there. 1, 2, 3, 4, 5. And one is, I think you are entitled to 41 lakhs. 2 is entitled to 2 lakh 75,000. 3 is entitled to something like 15 lakhs. 5 is entitled to 28 lakhs. And who is this? And number is, see, this Akhil Sokia is entitled to 1 crore 17 lakhs. How is he going to disburse that amount? Tell me. How is he going to disburse? You have not paid the entire amount. Then what about the interest? Who is going to pay the interest? This is not there. The calculation is wrong. This calculation is wrong.
PC Dhemaji, we have.
When there is a direction to do as per the act of area, why haven't you taken note of who has made this calculation? Yes, Mr. DC. Have you seen the calculation?
Yes, sir.
Have you seen the calculation? Now you see section 26 to 30
Yes,
is to be
sir.
taken into account.
Yes, sir.
30 includes 100% solution.
Yes, sir.
26(1) includes the market value of the land.
Yes, sir.
26(2) includes the multiplication factor,
Multiplication.
which will be
Yes.
the double.
Yes.
Then you have 30, 31. 31 says about interest from the
Yes,
date
sir.
of the notification till the date of the award
Yes, sir.
at 12%.
Yes, sir.
Then you have 100% solatium
Yes, sir.
on this amount 33.
Yes, sir.
See your calculation as per annexure 1. See your calculation. Tell me, where is the interest element? Where is the
Yes.
interest element?
Yes, sir.
There's no interest element. This calculation is on the face of it wrong.
Yes, sir.
What is this type of calculations you have done? And who is going to pay the interest? Isn't he entitled to the interest from the date of the delivery of possession?
Yes.
Then, have you seen section 80?
Yes, sir. Yes, sir. Interest is, the petitioners are, liable to pay interest, sir.
How much?
Whoever,
From 9% for the first year and 15%
Six.
from the next year. Where
Yes,
is
sir.
it in this award statement? Why the award statement does not include all these things? And you have merely made 3 crores. It would be minimum 9 crores. When there is a specific direction, you have to complete. Madam, you don't take that money. Don't wait for the timing. It will order to enable. We'll have it on 29 because this award statement which has been made, did you file an affidavit? Has anybody filed a affidavit? Where is the award statement? Why haven't you placed it? Why are you going to consider this? There's a contempt application file. Is it not required? Filed by on behalf of the respond number 1. Who is the respond number 1? No, take on. Who has filed the affidavit? Has anybody filed affidavit? My goodness. So if you have not filed the affidavit, why we should not hold you in contempt? We are not going to look into all these things. And what type of adjudication is this? 3 crores without taking into account anything. দেখো, heard Miss so and so, heard Miss so and so, the learned counsel appearing on behalf of the petitioner. The RM Das appears on behalf of the respondent number. Respond number 2 and 4. 2 and 6.
4, 6, and 7.
Huh?
4, 6, and 7.
2, 4, 6, and 7. Mr. G. Pego appears on behalf of the respondent number 3. And
First, then my lord, who probably was the deputy commissioner.
it's okay, wait. 3. Who's- The instant contempt application has been filed alleging willful and deliberate violation to the order dated 15/5/2023, passed in WPC number 4825/2018. A perusal of the said order reveals that the this court had specifically directed the respondent authorities to assess the compensation in terms with the provisions of the Right to Fair Compensation and Rehabilitation Act 2013, and to pass the necessary award and disburse the assessed compensation amounts to the petitioners in an expeditious manner, but not later than an outer limit of 6 months from the date of receipt of the certified copy of the order. Full stop. A perusal of Annexure 2 to the contempt application shows that on 25/5/2023, the certified copy of the order have been placed before the have been submitted to the Deputy Commissioner Dhemaji, and the same was duly received. As the period of 6 months have already elapsed therefrom, and no steps were taken, the petitioners, being constrained, has filed the incident application seeking initiation of contempt proceedings against the respondents. The record reveals that the service upon all the respondents were complete, and however, none of the respondents have filed any affidavit. It is further seen that on 17/9/2024, an instruction was placed before this court by Mr. R.M. Das, the counsel appearing on the counsel appearing on learned counsel appearing on behalf of some of the respondents, wherein there is a mention that an LA estimate for an amount of rupees 3,24,85,758 was prepared and was sent. Was prepared. This court inquired with the learned counsels appearing on behalf of the respondents, including the Deputy Commissioner, District Commissioner Dhemaji, as to whether an award has been filed in pursuance to the estimate so prepared. Have you filed the award? Has the award been approved, Mr. DC?
Yes, sir.
It has been
It
approved.
was approved earlier. Yes, sir.
No. After you made this 324, has it been approved?
It is approved, sir. I mean, before I joined, it is approved, sir. 324.
When did it happen? When was it approved?
Sir, it was approved, I think, 6 months ago, sir. And accordingly, the department we sent an requisition to department for crediting that amount, sir. 3 crore 24 lakhs, sir.
Award has been approved and filed. When?
Sorry, I beg your pardon, sir. I just need to check the record, sir.
You see, when you pass an award,
Sir,
earlier award which was passed,
sir.
the court said that you have now to pay the compensation in terms with this,
Yes, sir.
as per the right to fair compensation. So
Yes, sir.
therefore, 26 to 30 comes into play. So
Sir.
so the determination now has to be done as per the new act and not the old act.
Yes, sir.
Now, when the determination is done by the new act, you therefore have to pass the supplementary award
Yes,
or
sir.
another award to that effect
Yes,
whereby
sir.
that supplementary award would be the conclusive evidence, because otherwise it does not become conclusive evidence unless you file it. Did you
Yes, sir.
get the approval from the government?
No, sir. No, sir. Regarding that, that
Then
revised one, sir, we have.
the award
Yes, sir.
not filed. Award not passed, then how is he going to pay? As of now, there is nothing has been done. Inquired as to whether any fresh award has been passed or any supplementary award has been passed and approved and filed pursuant to the directions passed by this court. The counsel is appearing on behalf of the respondents as well as the Deputy Commissioner, District Commissioner Dhemaji, seem to be unaware of the said aspect. Under such circumstances, this court again fixes this matter on 24th, 22nd of 21st, on 25th of November 2024, on which day the Deputy Commissioner, the District Commissioner Dhemaji, shall apprise this court as to whether there's any fresh award as well as or supplementary award have been passed, have been approved and filed before in his office pursuant to the directions passed by this court on 15/5/2023. Can you do it by yourself or should I again call the DC? No, we'll have it on 26th. On 26th. August. Mr. DC, you kindly apprise him as to whether it has been done or not. Otherwise, it is a gross violation on your part. And there's no estimate of anything out there. So as of now, there's no restitution. So obviously, the land has to go where? Where's the land? What have you done to the land? What have you done? Okay, return the dike and take away the dike and return the land. I want the award filed and brought before this court on the next date. Otherwise, why will they pay? Tell me. Why will the government or the budget sanction? You don't have an award. Award is the basis on which you pay. Then, then we'll again have it on 27th. And if you are not there, and Mr. District Commissioner, if your counsel is not there on 27, because 26 I am having this, 27, then check, get a hold of another counsel. Yes. Yeah. Personal appearance of the year is dispensed with.
Thank you, sir.
Yes, what is this? How can you do it?
Instructions are awaited. Instructions are awaited. I have written to them. But
Instructions are awaited means?
minor
It is a simple case how the circle officer has the business. And for getting a particular notification from there, you are saying that the instructions are awaited. And since then the matter has been coming from 8/11, does it take such a long time?
I have written
Hello?
to them.
We have the revenue secretary present in the court day after tomorrow. Let us see why does it take such a long time to get an instruction to that effect. This court had sought for a simple instruction by an order dated 8/11/2024 as to how the circle officer have been empowered to go ahead with the partition, which power has been specifically reserved upon the district commissioner as per the Assam Land and Revenue Regulations 1886. Footstep. On the said date, the learned standing counsel for the revenue department sought for an accommodation to produce necessary instructions. Accordingly, the matter was fixed on 13/3/11/2024. However, to 13/11/2024 for providing such instructions. The record further reveals that on 13/11/2024, no counsel appeared on behalf of the revenue department. And accordingly, the matter has been listed today at 2 p.m. Pusto. Today, Mr. A. Bhattacharjee, the learned standing counsel of the Revenue Department, submits that instructions were sought for, but however, the Revenue Department of the Government of Assam have not responded to the same. Taking into account the above, this court directs that who is the person? Whom have you asked?
Principal Secretary. Principal Secretary.
Directs the Principal Secretary to the Government of Assam Revenue and Disaster Management Department to be present before the court on 27th of November 2024 through video conferencing line at 10:30 a.m. to be provided by Mr. A. Bhattacharjee, the learned counsel, standing counsel for the revenue.
Madam, can it be on 28th? He's out of India, I'm told.
Then why you are asking him only?
But he-
Are you saying that the revenue department if is not functioning otherwise? Then
by any other-
why? There is no other person in the revenue department. Whom have you asked?
I have written to Principal Secretary, but now I get to know that he is out of station.
Then
So can it be by any other secretary?
who? Who is there? Tell me.
Secretary, any secretary revenue, when I'll
How do I know? I am not a person who is working out there in the revenue department, or I am not their counsel. How will I know which are the other council secretaries? Give me the name of any name. I'm not asking the name, the designation,
secretary revenue. Secretary revenue.
the secretary revenue.
Oh, like,
Per contra, Mr. S. Bottakur, the learned counsel appearing on behalf of the petitioner, submitted that the interpretation so sought to be given by uh, the state government to section 122 would amount to interference to the functioning of the panchayat of the panchayats, as well as also would lead to would amount to with interference in all matters of the panchayat by the state government, in spite of the fact that by way of a legislation, such powers have already devolved and upon the panchayats. He therefore submitted that the manner in which the respondent state have taken the decision on 29/6/2024 by issuing the notification dated 29/6/2024 was not in accordance with law and accordingly liable to be interfered with. He further submitted that the petitioners, the respondents be further directed to bring the said tender proceedings to a logical conclusions in as per the mandate of Rule 47 of the rules of 2002. That rules of 2002. Mr. Bhattakur, remaining I will make it CAB, huh? But I am going to dismiss your petitions, but dispose it, not dismiss, because that thing has to be interfered with for granting extension. That has to be interfered with, but otherwise I would not touch on that notification and direct them to go ahead immediately. Why? And does it take such a long time?
Within a specific period of
Within
time.
a period of 3 months. 3 months you have to complete it because you can't keep on running like this. Because you can't exercise 105 in this manner. 105, 5. You can't exercise in there. It is only when you are not getting a value, then only it can happen only. So you have to immediately do it if it is a policy decision within 2 months.
Item 43 is on similar. 43, that's supplementary question.
40,
43, 43.
only 13 will be segregated. Huh? Huh? Yeah.
13 earlier list is continued. 13 earlier list is continued.
Okay, 13 also I do it CAB then. Then I will dismiss the 13. I will do one thing, uphold it, and in view of this order, that they cannot grant an extension, we'll stop, direct them to immediately do it through the, yeah.
Order of this court, my lord, in terms of this order, we continue. And against that order, I have filed an IA for state.
As per the,
No, all these orders will go.
as per this honorable High Court, my lord, on 12/7/2024, I was continuing. As per the honorable High Court order, I was continuing.
You are who?
And the earlier list,
Petitioner.
yes,
You are the petitioner.
yes,
You are running.
running. As
And
per the-
that aspect has been stayed in another petition. How is it
Yes.
possible?
As per the direction of this honorable court, my lord.
We are setting aside, so you can't run like that.
Right.
So your petition also will go. Or we'll have it some other day. Because next week it is school. Let me give it on this judgment. I'll give it on Friday, next Monday.